Today's question is the following. My cousin and I co-own our deceased grandparents' property. How do I make sure my half goes to my daughter when I die? And the reader goes on to explain, we both want our children, not the surviving owner, to inherit our shares. We both, my cousin and I, live in the state of Wisconsin, and the property is in Michigan. Does the inheritance info go into our deed or each of our wills? So great question, and there's two ways you can do this. It depends on how you hold title from your grandparents. Now, if you hold title as joint tenants, then the survivor of either of you would inherit the deceased person's interest, meaning you pass away first, cousin inherits the whole thing. But what I think is you probably hold it as tenants in common, and if you hold it as tenants in common, then it allows each of you to dispose of your interest in the property according to your own estate plan. So first thing is check the deed to see how you hold title. Then, to your second question, you can transfer your interest via either deed or via your will in Wisconsin. In Michigan, I'm not licensed in Michigan, so check with the Michigan lawyer about the ways you can hold property, but it's possible you could do what we call a transfer on death deed to each of your daughters upon death, or a better method, if there's more than one each, I would recommend a trust. You could each put your interest in the Michigan property into a trust, and you could also put your interest in any Wisconsin real estate into the same trust. So you could have one trust that holds real estate in both Michigan and Wisconsin, and upon your death it would pass it to your daughter without the need for a probate. If you use a will, you can execute a Wisconsin will that names the property in Michigan, and you can say, I want to leave it to my daughter. But if and when you pass, your daughter's going to have to open a probate in Michigan, in the county where the property is located, and a probate in Wisconsin, in the county where your other property is located, and do two probates, one in Wisconsin and one in Michigan. And you're likely going to need to hire a lawyer in both counties, which with the lawyer and the court fees, I'm not sure about court fees in Michigan, but there's court fees in Wisconsin. I'm sure there's some in Michigan. They could be higher or lower. Those fees will add up. So for a situation like this, I would suggest looking at a revocable living trust. You can deed both the Michigan property, any Wisconsin real estate, and even property in another state, let's say Florida, into one trust, avoid probate on all your assets upon death, and get it to each of your intended heirs, which sounds like for you and your cousin it's your daughters. But again, look at the title to the deed. I recommend you sit down with a good estate planning attorney, bring the deed in, show them how title is held, and they can lay out your best options for this situation. So great question, and thank you for asking.